I noticed there are some typos in my slides in all these lectures. I do apologize, and thank you for pointing it out. If you have spotted a mistake, it might be my mistake. So please point it out so that we all know. And I think in the end, because you don't have to attend all the lectures, if you have missed the lectures, in the end I think I will make a page of notes specifying the errors in the slides so you don't get misled for your exams. Okay? So please let me know if you're aware of any of these things. Age and sex. Traditionally, in the old days, you would expect that the father would stand a higher chance of getting the custody of older child, and for mother, they might have a better chance of having the custody of girls and younger child. That's because it is assumed, I think, that mother are natural carers, especially for young infants. It's not a matter of principle, but it's a trend. It's a trend that we sort of still continue to see these days. But it is not necessarily the case. And in recent years, we have seen more fathers who are caring and capable of taking care of children, even young and female children. So it's not necessarily the case that girls or young children would inevitably be taken care of by the mother. Okay. To give you an example, it's a settlement I have seen. Is that the father at the time was about 40-something, in his early 40s. The mother was not even 30 years old. There were two young children. They were about 6 or 7, something like that. One is a girl, one is a boy. And although we reached a settlement, but we also think that the settlement would reflect the result if the matter proceeded to trial. The custody was joint custody, but the care and control of the girl and the boy was actually granted to the father with reasonable access to the mother. I think one of the considerations is that the mother was still very young. She was not even 30 at the time of the settlement. She was young. There is a high possibility that she can look for a new boyfriend, have a new husband, and set up a new family. She has a whole life ahead of her. And even though she was not working, but the duty of looking after the children was actually shared between the mother and the father. So even though the mother was the so-called stay-home wife, she did not assume the majority of caretaking, the child minding. But by comparison, the father, he was in his early 40s. He has stable employment, even though he works. But it's clear that compared to the mother, he can provide for stability, and he has no intention to start a new family with a new girlfriend. Okay, so that involves a very young girl. But even then, it is possible that the care and control is given to the father instead of the mother. For sibling unities, it means that if there are more than one child involved in the family, then it is strongly in favor of keeping the siblings together with one parent. So you would have one set of order for all the children instead of different arrangements for the brothers and sisters. That's especially when the children are not that far apart in age, and they have grown up together, they have each other in their company for years. So it goes to stability and status quo as well. The reason why, again, we have sibling unity, it's because in a divorce, in a split of household, children are smart and they're also sensitive. So if you have sibling unity, you can have somebody near your age at your company to go through this emotional stage of a split of a household in your family. You can have mental and emotional supports between siblings. Okay. But sibling unity is subject to bonding, subject to the closeness, how close the siblings are to each other, the difference in age, difference in their characters, personalities, and other backgrounds. In Jonathan and Jaden's situation, the mother wanted to take both children to Australia. Originally, the father objected to it and wanted both children to stay. But at some stage, he conceded. He only wanted the younger child. The reason, well, it's complicated. The reason is that, firstly, there is a age gap between the two children. They're very different. Jonathan was about to reach his majority. He will be soon out of the hand of his parents or the reach of the law in having parents. But Jaden was still very young, and his situation is not as bad as Jonathan. Even though he has some learning problems, he still goes to class. He's okay to interact with his friends and classmates at school. There are no other problems. But with Jonathan, it's much, much worse. It has reached a stage where it's basically, even if Jonathan stayed in Hong Kong, there is nothing, basically, we could do to change his mind, to help him improve psychologically, and to encourage him to go to school. It was very difficult. But then there is still hope and chance for Jaden to develop into, or to have a normal childhood. Okay. Compared to Jonathan. So in the end, he agreed on splitting the siblings. And that's the order being made after trial by the judge. We conceded on Jonathan in those circumstances. It's a really sad case, indeed. And an interesting fact is that the case was heard by a deputy district judge, and I think that was the first big trial she dealt with. And after the trial, she no longer sat to hear a trial on family law. I think she has now switched divisions. Probably too much for her to bear with. For role of natural parent, it usually refers to case laws that say that grandparents, domestic helpers, and aunt and uncle cannot substitute the role of natural parent, especially for mother. Okay. By comparison, I think it's a minor consideration. And you would have cases where the mother or the mother is simply not suitable to look after the children, such as the situation with Jonathan and Jaden. So other than sibling unity, role of natural parents, of course, there are all sorts of background characteristics in a particular case you will want to consider. And I can't specify all of these situations here for you. Okay. So that means you are free to consider anything that you find relevant in considering a custody matter. And in your assignment, of course. Okay. Any harm which the child has suffered or is at risk of suffering. The typical examples of physical and sexual abuse. If you can prove with real evidence, not just allegation, that of sexual or physical abuse, then the abuser is very unlikely to have custody or care and control of the children. Probably he or she would just have access. The access might also be minimal. The contact between the abuser and the child will also be minimal. It depends on the gravity of the abuse or imminency, and there might be some limits and condition attached. So you might have just electronic, and it might be accessed under the supervision of the social welfare department. Sometimes scolding, screaming might amount to harm in this context. Okay? So if you have very strong evidence such as video, voice recording of parents scolding, screaming at the children, then this is also, I think, a strong factor against a party who will be seen as abused or neglected the child to some extent. So it doesn't have to be as serious as actual sexual abuse or actual physical abuse. In some cases, the screaming and scolding and the yelling can be so overwhelming that you find it very uneasy to put that child with that parent. It can happen and amount to harm in this situation. And if a parent has behaved in such a way that he or she cannot manage his own business or run the household or take care of the child, such as a heavy drinker, drug user, a gambler, super hot-tempered, then it might put the child under stress or in unsuitable environment. It might cause adverse psychological impacts on the child. Then in that case, I think can also amount to harm, which the child is suffering or at risk of suffering. So all sorts of bad behaviors. But again, you remember, I have emphasized a few times that this is not about moral judgments. So even if you have used drugs, for example, of course it looks bad on that parent using drugs, but in refusing custody or care and control to that parent doesn't mean that the court makes moral judgment. It reflects on the parent's ability to take care of a child, and it reflects the possible harms that would be caused to a child if the child is under the care of that parent. Okay? So don't make that judgment in your head when you encounter these facts. The capacity of each parent or third party to meet the child's needs. So this is an overall assessment of a parent's ability. So in the absence of abusive behaviors that we just addressed, the court would basically look into the day-to-day care of the children. So who is the primary carer of the children? You will look at who spend more time with the children, who make arrangements for the children's routine, who help with their homework, play with them, bath them, put them to bed, take them to school and extracurricular classes. So a full-time parent would usually have advantage in this regard, especially when the children are young. If you have a full-time mother, then it would look like at least that parent has all the time to devote to the caring of the children, right? Third party is a bonus. Third parties usually are grandparents, aunts, domestic helpers. It's a bonus, but not everybody has that. The fact that you don't have a helper, it doesn't mean that you can't take good care of the children yourself. It's just a bonus. Okay, so these are the factors I want to bring your attentions to. Do you have any questions? Any observations, comments, thoughts? Anything that are confusing to you? Okay. If not, then I will go into procedure. It's relatively short on procedure. Okay. So this is a very basic divorce flowchart. You remember from last time, after you have the petition, if you have children dispute, you would have a children's appointment. And if you have dispute on finance, you will have first appointment hearing. Usually, after the petition, these two hearings would be fixed on the same day. That's the usual practice. There's no reason why to fix two separate days and waste two sets of costs for the preliminary hearings. And these are, if in the civil context, these are understood as case management hearings, but they're specific to children or finance. Okay. And these hearings can be adjourned from time to time. So what you will see in court documents is that the first appointment hearing, and then it will be adjourned to the second first appointment hearing, and then adjourned to the third first appointment hearing. The same with the children's appointment. What happened is that children matters will be dealt with first. At the first hearing, you have the CA and the FAH together, and then we will be focusing on the children part. So the first appointment hearing might be adjourned, sine die. You might not have a fixed day for the next first appointment hearing, but the children's appointment will be adjourned to a fixed date, depending on the diary of the courtroom. And then it will be adjourned for a few times, and then when the case, maybe once or twice or three times, depends on the complexity of the children matter, and then the children issue would be heard in a CDR, a Children's Dispute Resolution. A CDR is basically a court, is a mediation conducted in the court, basically. It can be understood in that way. And so the court would have the parties inside the courtroom and try to settle on children issues. You can settle the children matter fully. You can settle part of it. I have heard CDL where the parties would insist on the proposals, but say they have their respective proposals, and then we can agree on if at the trial the court rules in favor of the father's proposal, then what would be the access arrangement for the mother. And then they can also agree that if the court in the end ruled in favor of the mother, what would be the access arrangement for the father. So you can agree on these things. You don't have to settle the whole thing on children. Okay. If any part of it is not settled, then it would go on to trial. And after the trial, after hearing evidence and closing submissions, the case would be adjourned. Of course, the judge would have to write the judgment on children, but at the same time, the case would also be adjourned to a first appointment hearing. So that's why if you have a timeline vertically on this chart, after the children matters that have been dealt with, you will go back to a first appointment hearing. It might be the first appointment, might be the fourth first appointment. It depends. Okay. And then it's a similar procedure where when the documents are ready, the first appointment would be followed by a financial dispute resolution, an FDR. So that's kind of like a mediation on finance conducted in the court. And if any part of it is not settled, then it can you go to a trial. Okay, does it make sense to you? So you can understand children's appointment hearing, first appointment hearings as case management hearing. It's just that there are two separate things that need to be adjudicated separately. So you have two different names. Okay, so you have case management when the matter is ready is for mediation on children and then trial on children, and then you back to case management and then you deal with the finance part in a similar flow. This is a mandatory procedure by the relevant practice directions. You have to follow this flow for a children's appointment, followed by a CDR, followed by the trial on children matters, unless directed otherwise by the judge. Sometimes, when there is no chance of settlement at all, especially when experienced counsels are involved and the court can trust the counsel's opinion, then you might skip the CDR. It is possible that you can skip the CDR if it is suitable in the view of the court. But this is more likely for finance. There's always room for talking some sort of settlement, some sort of agreement on children arrangements. So normally you will follow the blue part on children. From the children's appointment, or the first appointment at the beginning, on the very left, to the CDR, to the trial, to back to the first appointment and the FDR, you would have the same judge. But if you fail, if the parties fail to reach a settlement at the FDR, the case will be directed to be heard by a different judge after the FDR. In the old days, what happened is that after the FDR fails, the case would go back to the principal family judge, who one of his main tasks was to oversee all the cases, the case management of all the cases. So the case would be adjourned to that principal family judge for a pretrial review, and that judge would assign the case to another judge who has never touched this case before on the children matter or the FDR. So in a family case, it would have gone through at least 2 judges. I've seen cases who have gone through 5 for different reasons. There is a new practice directions. In the old days, it will be refixed to a different judge, and you wouldn't know which judge that would be, so you have to wait. But it seems that under the new practice direction, the new scheme of PDSL 10.4, then the judges will work in pairs. So it sounds like when you know who your first judge is, you will know already if the FDR fails, who will be your judge on ancillary relief trial. Strategically, this is important for practitioners because some judges are more experienced in the family court. You would trust that they won't make a mistake in exercising the discretion, and you know where to get to their sympathy. So if you have a better judge, better in a sense that is more experienced, that is more likely to rule in your favor, try to settle before the FDR. Because for the trial on ancillary relief, the judge might not be so experienced, and if you have very complicated facts, then you might not get a judgment that sounds right to you, and then you might have to spend time and money for appeal. So the practice direction for children is PD 15.13. The reason why we need this is to support mothers and fathers so that they are able to effectively parent their children post-separation or divorce. The intention is to ensure that whilst the best interest of the children remains the court's paramount concern, that lasting agreements concerning children are obtained quickly and in a less adversarial atmosphere. The focus is therefore on the children's best interest together with the duties and responsibilities of their parents. So I know that you have done civil procedure. You've never seen a courtroom mediation in civil procedure, right? Usually just case management, pretrial review, and then the trial. There is no courtroom mediation. This is specific for family cases in the family court. So this flow chart, it's not in the civil procedure rule. It's in the practice direction. It comes from practice directions. Do you know what practice direction is? Have you learned about this concept of practice direction? It's not legislation. It's not a rule or a law per se, but it's something that you would adhere to in practice. So if you go on to become a lawyer, apart from ordinances, case law, you also have to pay attention to practice direction, which can be found on the judiciary's website. If you fail to observe the practice direction, it can amount to a breach of, in a sense, a breach of the civil procedure rules. So if you do tort, if you do personal injury, there is a personal injury practice direction that you would have to observe. Failing which, you might have punishments, such as reflected in cost, for examples. And you will be received in dismay by the court if you don't follow it. So even though it's not a law, you have to follow it, basically. Okay. So for a children's appointment, you would remember there is a notice in Form I when you petition for divorce and then there is dispute on children. There is a notice of children's appointment, and then the petitioner will have the notice will be served on the respondent. 14 days before the children's appointment, or if the court directed otherwise, each of the parties would have to file and simultaneously exchange the children's form. It's called the Form J, the children's form, and a concise statement of issues relating to the children. What is the Form J? The Form J can be found and downloaded at the Practice Direction 15.13. So this is the practice direction. If you go to the judiciary website, you can find it here. There is a Form J, which if you click on it, you can download it, which I just did before the class. It looks like this. Okay. So at the beginning, you would have details of the children. You have the name, the parent's name, address, the children's details, care arrangement, okay, any issue with supervision of a probation officer, current living arrangements, okay, how much time you spend together, how much time, let's say I'm the mother, how much time the children spend with me as the mother and with the father, and other carers such as grandparents, etc., or aunt. Okay, who live with you, the relationship. So usually just me and the children. Sometimes you would have the helper, domestic helper sometimes. Sometimes you would have a boyfriend, you have to disclose that. So all these day-to-day, daily care matters, sleeping arrangement, ECA, homework, entertainment. So you have to give all these details for current arrangements. Accommodation. 2.7 is stability. Stability of living environment. Changeovers between you, me, and the father. If I have the parent, I have the child, how does the child communicate with the father? 2.9. and other extended family members, grandparents, aunts, uncles, manners. So that's about extended supports from family. Okay. This is a little long. And then you have schooling. Traveling time, schooling. How do you go to school? How do you come home? Who picks up the child from the school? Before and after school care arrangements. Okay. How will the school be informed about your family's change of circumstances? So how do I make sure the father also knows about the schooling situation of the child? Can I agree to attend parents' day with the father? Okay, illness, what's the emergency contact, problems at school, and health, finances. That is more relevant to the maintenance of children. And future arrangements, which is basically the same as the current arrangements, but you talk about your proposal for future arrangements. Okay. It's quite mundane to look at that form if you're not a parent yourself. It's really detailed, but you will understand that when you are a parent. Okay. So 14 days beforehand, you will have to complete that Form J. You have to file to the court and also exchange with the other party simultaneously, and then a concise statement of issues. What are the actual disputes in relation to children arrangement? There is a point saying that if the children's appointment is not heard at the same time as the first appointment, then you will also file a brief chronology and list of orders directions sort. Usually in a first appointment hearing, you would have to provide a brief chronology and list of orders. So what it says is that if you don't have it together, then you have to complete the picture and do those relevant documents as well. To me, I rarely see, especially for the first hearing, I don't really see a situation where a children's appointment would take place before a first appointment hearing. If you have a urgent matter for children, you don't wait for the children's appointment. You take out a summons on an urgent basis, and then normally there will be a hearing date on that application before the children's appointment, if there is such a day available. So I don't really know a situation where you have a children's appointment before a first appointment. But then of course it's possible when you are waiting for a CDR, and then you might not be dealing with finance at that stage. Then maybe you would just go to a children's appointment without hearing the finance part. And then to assist the court to have an overview of the case, you will want to have a brief chronology and a list of orders. And the parties should file and serve an estimate of cost in Form H before 4 p.m. on the working day before the hearing. Inevitably, if you look at the practice directions relating to matrimonial practices, you would have to file a Form H for all these hearings, for all the children's appointment, first appointment, CDR, FGR for trials. You always have to file a Form H at 4 p.m. the day before that hearing. Most of the time, a lot of people do not follow this. That's the reality, but it's not appropriate. sometimes the parties might not be able to file it the day before. They will bring copies to the court and also provide it to the other party at the hearing itself. The Form H is a very short document. Okay, it looks like this. So you will have part 1 is the estimated cost incurred so far and including this current hearing. Okay, what do you have spent actually? Part 2 is estimated cost after this hearing up to FDR, or in a children's situation it can be CDR. Sometimes people would change this word FDR to CDR. Okay. For the items, you have fixed costs, solicitor's cost, disbursement, counsel's fees. So you have to try and break it down as much as possible. And then the third part is estimated cost after the FDR and including the trial. The reason why you have this line, this timeline at the FDR is simply because you might settle at an FDR. And so you don't have to estimate the cost for trial. You might just settle. And that's why it's a separate part. The point of having a Form H is to alert the parties as to cost. Because when people are divorcing, they are highly emotional. They just want to quarrel and fight for everything. So easily, the legal cost can escalate. Of course, you act in person, you don't have to file Form H. You don't even know the practice direction, I would assume. So the Form H is a way to tell the parties to pause, to reconsider how they want to handle their divorce by looking at how much they have spent, how much legal costs have accumulated, and how much the lawyers are about to charge them if they continue the litigation in this way. So they can consider whether they want to spend the money and time to continue to fight or settle and save the money and time. The biggest reason is to alert the parties. It also safeguards parties from outrageous legal fees, because you have to submit the Form H to the judge, who will be basically doing the whole case for you before the FDR. So the firm has to report genuine figures and reasonable estimate. It would put pressures on the lawyers so that they won't charge you without basis and outrageously. At the children's appointment, the judge might give some directions for the filing of the social investigation report or international SIR. The social investigation report usually is called at the first hearing, and as I said, from time to time you might have updated reports. The international SIR is different from the SIR. It's when you have a relocation, when a parent wants to take a child overseas permanently, then there will be an international SIR. It's different in the sense that the social welfare officer in that jurisdiction will look into, well, for instance, if you want to go to UK under the BNO, and then you will have to propose where you're going to live, where the children would go for schools. And then the international social welfare officer would investigate into that neighborhood, into that school. If you have family overseas in the UK, the social welfare officer would also go visit your extended family members over there and just talk with them. The international SIR is even more neutral in the sense that it should only reflect the environment overseas, just so the court knows, has a view of what it is like over there. It doesn't really make a recommendation of whether relocation shall be approved. Whereas in the relocation situation, the SIR would have a recommendation as to the custody, can control, and the the relocation, whether it should be allowed. Okay. For expert reports, they usually don't arise in the first hearing. Maybe they might not arise at all if there are no special issues, such as psychological issues with the children, or if there are such issues, the expert reports would normally appear at a later stage, even after the CDL, perhaps. The judge may also give directions on limited affirmations or affidavits from the parents or from other third parties. Now, at the beginning of the children proceedings, you would have the Form J, the concise statement of issue. In order to save cost and in anticipation of the possibilities that parties might settle at a CDL, normally the judges would not make directions for affirmation before a CDL. That is to save your money. So you don't have to write those very long, detailed affirmations in accusing each other. It also prevents the situations of parties engaging in confrontations before they can have a CDR. So in other words, without an affirmation, you might stand a better chance of settling at the CDR. I can't show you a real affirmation, but then they can be very, very long. I've seen an affirmation for a short application. It's not even for the trial, of 80 pages. Of the mother accusing the father of physical abuse of children. It can be. And when the case was adjourned to deal with the application, there were 3 affirmations from the mother and 2 from the father. They are all at that length. So imagine if you have those things before the CDL, you can't settle because you're already so entangled in that fight. You can't change your mind at that point for a CDL. So usually at the CDL, the evidence is very minimal. You would have a social investigation report. You would have the parties' respective Form J, the concise statement of issue. And then you would have a proposal on children arrangements. If you have counsels or solicitors, you have a submissions as well. You don't normally have affirmations at CDR stage. For affidavit from other third parties, they simply refer to third party carers, such as grandparents. The judge may also, at a children's appointment, at the case management, appoint an official solicitors, make orders in relation to custody and access, including interim orders. One of the big purposes of children's appointment is to discuss interim orders. It is always easier to talk effectively with the other party in person rather than by way of solicitors' correspondence or by WhatsApp between parties. If you can agree on things outside of courtroom on the day of the hearing, then you can tell the judge, and the judge can make it as part of the order by consent. But even if you can't agree, and if there's such need to make interim arrangements, then the court also has the jurisdiction and power to make interim order, such as interim care and control, who the child is going to stay with for the time being, and how the access should be for the time being. So at children's appointment, the judge can also adjourn the matters to mediation, collaborative ADR basically. ADR is always encouraged, and even though CDL is part of the mandated procedure under the practice direction, if in a case where the parties are sensible and they're already in the course of arranging for mediation, or they have had mediation and they have a further session further rounds in near future, then it might be cost saving and sensible to adjourn the the children's appointment sine die. Sine die means TBA, TBC, TBA. So it's to a date which is not fixed yet. And the parties, for the time being, would be directed to attempt mediation in their best endeavors. So it depends on what happens with the mediation, if CA is adjourned for mediation purpose. If your mediation is successful, you simply file a consent summons into court, and then that consent summons will be made into an order by consent. Even if mediation fails, then the parties procedurally should write jointly to the court to report on the failed mediation, and the court would fix a new date for the next children's appointment. So the whole court procedures would revive. And it is very normal that you would see in the court's direction that parties are directed to attempt mediation and report back on their mediation progress some days before the next hearing. It's a usual direction. So if a CDL is not appropriate, you can fix a date for hearing, for trial. You can, the judge can also direct the attendance of the social welfare officer at the hearing of CDL. The judge can direct the parties to attend counseling, parenting education program, and the judge may direct a judicial interview. So at the CDL, you will have a notice of hearing in Form K. And 14 days before, you will need to file and exchange a detailed statement of proposal in relation to the future arrangements for the children. And you will need a Form H. 4 p.m. the day before hearing. The judge is like a mediator. It says here in the PD that the judge will act in the role of a conciliator. The parties shall attend the CDL. The attendance of any parties, social welfare officer, must be specifically directed by the judge. The judge may talk to the parties directly and not only through the parties' lawyers. The judge is like a mediator, and when I do unlike a formal substantive hearing, my role for me as a lawyer is to try to facilitate the settlement, but of course I represent one of the parties. But unlike a formal hearing, I don't like to use legal jargons. I don't like formalities. And my little trick for pushing for settlement is that when my client does not want to listen to me and my advice for doing this CDL, I will find a way to tell the court that it's my client that is being unreasonable, not me. Please talk to them directly. Okay? Because sometimes when your case is really outrageous and unreasonable, the judge will look at counsel and be like, what the hell are you talking about? But in a CDL, they can talk to the clients directly. They don't have to put all the blames on me. And inside the courtroom, unlike a litigation situation, the atmosphere is very relaxed. So the judge and the clients, the parties, can talk to each other relatively freely. And also in a formal setting, if it's not a CDL or an FDL, when counsel or solicitors are instructed, we have the right of audience. So normally the clients are actually not allowed to talk to the bench. If if the client wants to talk to the judge directly while engaging a lawyer, then I would have to ask for leave from the court to allow the client to speak personally. But then you don't have to do that as CDR. It's given that they can talk to the judge directly. A CDR and FDR, including an FDR, as of now, they usually start at 10:30 in the family court. Because at 9:30 you would have directions hearings, such as first appointment and children's appointment. But you can start your negotiation outside of courtroom way before 10:30. So what happens at a CDR is that you will make submissions and have discussions with the judge. The judge can talk to the clients, the clients can talk to the judge. And then the court will usually ask you to go outside, talk to your client, reconsider your positions and have further negotiations. You go back to the court, you report back on the progress and whether you're moving along or there's no room of settlement. So this would happen for a few rounds. You go back to the court, go outside, reconsider, renegotiate, go back to court, etc., etc. A CDR can last for half day. It can be morning, it can be afternoon, it can be full day. If it is listed for a full day or even for a half day, if there's some, if you see that the case is going into the direction of settlement, but you don't have enough time today, then the CDR can be adjourned to a further day for the CDR to be continued. Okay? But of course you want that day as early as possible if you can't have that early court day, because any moment the parties can change their mind. You want to settle as fast as possible, then you might want to have private negotiation to continue from the CDR or have private mediation. You can do that as well. The same judge, I'm on the second bullet point, the same judge will conduct both the CDR hearing and the FDR hearing as separate hearings. As a CDR hearing is not privileged, the same judge may hear the child-related matter at trial if settlement is not achieved in the meantime. And therefore, anything said or any admission made in the course of the CDR hearing shall be admissible as evidence in trial. This is very, very significant. It is the biggest difference between a CDR and an FDR. Also a difference between a CDR and a mediation. Because usually in a mediation, you will have a mediation agreement, and one of the clauses is that everything said is privileged, so you can't disclose to a non-party to the mediation. You can only disclose that you have had a mediation and whether the mediation has failed. That's about all you're allowed to say by that confidentiality clause in a mediation. In a CDR for children matter, there's nothing that is privileged. Because in practice, we would have solicitors' correspondence if it is for finance, or in civil proceedings. If you have learned this in a civil procedure, usually the negotiations will be marked as without prejudice, save as to cost. So if it's marked as such or as confidential, then you can't disclose that as evidence until you have a result of the trial, and then you discuss about cost. In children, there's no such thing. Nothing is privileged. Everything is at the table. You can't hide it. Okay? And after the CDR, you have the same judge for the trial on children. But in FDR, because FDR is basically civil on the money claim, is basically. So after an FDR, you have to change judge. Because what is said in negotiation, mediation in FDR will be privileged. You go to the ancillary relief without all these proposals and negotiations until you have a result of finance, and then you have to discuss about cost. Biggest difference between CDR and FDR. So because a CDR judge will continue to be the judge for the trial, CDR becomes very important. in a sense, because you get to freely converse with the judge, you will know kind of how the judge would rule in your case if it goes to trial. Some judge would even be as bold as to tell you, if I was to adjudicate, I would make such and such order, to put pressure on you. Because essentially the judge will be saying that if you go to trial, I will be exactly doing the same thing. But then you have to spend money and time. You waste your time and money on your lawyers and courtroom facilities. Not a lot of judges do this. Judge Malloy would like to do that, but she's retiring. So for lawyers, if you're experienced enough, you can hear those hints and indications from the judge. It's an important occasion for a client. But of course, the circumstances are always changing. You can argue other things for trial. But then at the CDL, the judge would also have a feel of the parties, who they are as parents. They might be able to remember that even before your clients go into the witness box. So this is very significant. Okay, and if you can't settle at an FDR, then a PTR will be fixed directly before the same judge. And then you will have directions on trial dates, on the filing of evidence. That's when you will usually have affirmations of the parents and parties. You would also have an updated social investigation reports. And if there are expert opinions involved, you will have updated expert reports as well. So similarly, before the trial, 14 days, you would have to file an exchange, a statement of proposal on future arrangements, and then you have the Form H. And then it's just civil procedure on the trial. Okay, that's all on the procedure. So the next lecture, we'll be talking about custody, can control in great details, and also relocation. Okay, thank you. Have a good night.